Welcome to meeting number 18 of the House of Commons Standing Committee on Justice and Human Rights. And also welcome Ms. Demoff, who will be replacing Mr. Kellaway today. Thank you for being here. To ensure an orderly meeting as we continue our study into domestic violence, I will outline a couple of rules. Just for all witnesses and members, understand that there is an interpretation button at the bottom of your Zoom screen that allows you to select the language that you would like interpretation for within your headsets. You don't need to change the language if you're speaking in a language other than what is being interpreted. Before speaking, please do wait until I call you by name or recognize you by name. As you're on video conference, please make sure that you unmute yourself before you start speaking. And if you're not speaking, I'd ask that you please keep yourself on mute. A reminder to all members and witnesses that all comments should be addressed through the chair. We have a platform for respectful dialogue, and we'll be maintaining that as well. We're very happy to have the witnesses here today. With the speaking list, Mr. Clerk and I will do our best to ensure that we maintain an orderly speaking list. You can raise your hand, which is at the bottom of your Zoom screen, if you would like to speak. So please just note where that raise hand function is. And again, if you'd like to speak, do unmute yourself before starting to speak, and mute yourself once you're completed. I do have these 1-minute cards and this 30-second card that allows you to judge how much time you have left for speaking. And so at this time, I'd like to welcome our witnesses for their 5 minutes each. Opening remarks. We'll be keeping time. As an individual, we have Janine Benedette, Dean Pro Tem and Professor at Law at Peter A. Allard School of Law at the University of British Columbia. We have Jennifer Cochin, who's a Professor, Faculty of Law at the University of Calgary. And we also have a representative from Hiatus House, who we have Genevieve Ishaq, who is the Clinical Director of Residential and Community Services. Welcome to the witnesses. So you will have 5 minutes each to speak. We'll start with Janine Benedette. Your time starts now. Please go ahead and unmute yourself. Thank you.
Thank you very much, Madam Chair, and thank you to the members of the committee for inviting me to participate in this hearing. As you heard, I'm a professor of law at the University of British Columbia, and my research focuses on legal responses to violence against women, with a particular focus in recent years on sexual violence. And I'm pleased to see that this committee is seriously considering how to address the problem of coercive control in intimate relationships, which is inflicted in most cases by men against women and girls. And I think it is important to note that while addressing this problem may serve to prevent further serious violence, and certainly the private member's bill in question speaks to the terrible mass killings in Nova Scotia, it's also important to understand that this coercive and controlling behavior itself causes great harms to victims, affecting their sense of self-worth and throwing up real barriers to accessing the resources they need to get away from an abuser. It's also important, and I would say this based on my own work, to recognize that coercive control may be a precursor to sexual violence in addition to or instead of physical violence. So I agree with the aims of this bill, and in general, I think such an offense could be useful for police and Crown Counsel. I can see that this offense forms a useful middle step between an assault charge and a peace bond in some cases. Having said that, I think it does bear saying as well that there is a history of some police and Crown failing to use the tools they already have at their disposal, and creating one more offense will not solve the troubling tendency to disbelieve women when they report violence, or the lack of other supports in the community to address the violence that they experience. So in the time remaining to me in my opening remarks, I just wanted to address some of the relationships and behavior that may be overlooked when we speak of coercive control, and mention a couple features of the text of the offense that could raise concerns about whether it will achieve its important aims. So for the past several years, my colleague Isabel Grant and I have been researching sexual violence across women's lifespan, focusing on the particular challenges that arise when prosecuting sexual assault against older women, against teenage girls, for example. And in our research, we saw numerous examples of coercive control against these victims that were age specific. So for example, in our study of cases involving teenage girls, we saw the single largest group of perpetrators were male family members, most often fathers, but sometimes brothers, uncles, and grandfathers. Most of these men lived with the girl in question, but some did not. And controlling behaviors included controlling what a girl could wear, taking away any privacy she might have, isolating her from other family members and friends, refusing to let her go to school or ride the bus. In one case we reviewed, a father refused to let his daughter speak to her brother, going so far as to separate them at meals so that they couldn't have contact with each other. In the case of older women, our primary conclusion was that the barriers to detection and prosecution when the abuser is a family member are significant. But in the cases we could find, we saw coercive behavior by husbands, but also sons, nephews, and grandsons. And these sometimes took age-specific forms, such as controlling access to necessary medication or doctor's visits, or cutting the woman off from transportation where she wasn't able to get around on her own. It also included cases of making the woman believe that she was forgetful and incompetent, that she was in the early stages of dementia, and therefore couldn't manage her own affairs. So I just want to say that while it is spousal or dating relationships that may come to mind first when we think about coercive control, I would urge the committee not to overlook these other kinds of relationships in which this behavior also occurs and is often a precursor to other violence. And I'll just conclude by saying there's a lot to discuss here in terms of the offense itself, in particular the mental element. But fundamentally, what I would say is that it's important not to create an offense that replicates some of the problems we've had with the criminal harassment or stalking offense. And I see some of those challenges here. So I'm looking forward to discussing that more with the members of the committee.
Thank you very much, Ms. Benedette, for being right on time. We'll now go to Jennifer Koshan, who's the Professor of Faculty of Law at the University of Calgary. Go ahead, Madam.
Thank you, Madam Chair, and good morning. I'm grateful to be joining you today from Treaty 7 territory and appreciate this opportunity to speak with members of the committee about the criminalization of coercive control. I'm part of a research team that's reviewing domestic violence laws across the country, and our focus is on how different laws and policies intersect both within and between Canadian jurisdictions in ways that can create barriers, injustices, and safety issues for survivors and their children. Our research is informed by the recognition that the harms of domestic violence are gendered and can be intensified and unique for persons experiencing intersecting inequalities such as Indigenous, racialized, and migrant women. I have 4 key points to make today about the criminalization of coercive control. First, that we should consider criminalization in the context of other laws in Canada. We now have recognition of coercive control in the Divorce Act and some provincial and family law and civil protection order legislation, but it's not yet recognized across all Canadian laws. The criminal law could, in theory, help to increase recognition amongst members of the public and legal actors that coercive control is a significant form of abuse. This recognition might help move us away from the current incident-based approach to domestic violence, which focuses on discrete physical acts rather than the ongoing and cumulative effects of coercive control. A new criminal law could also lead to validation of survivors' experiences and protection of survivors and their children from the harms of coercive control. And we know that these harms include death because coercive control is a risk factor for femicide. A criminal law could, in theory, also have positive impacts on other areas of law, both in legislative definitions of domestic violence and in how judges and other legal system actors understand and apply those definitions. However, I think we also need to look at how law on the books translates into law on the ground. And we do have some experiences in Canada to draw upon here. British Columbia was the first province to include coercive control in its family legislation, and case law shows that the reform has had mixed impacts on judicial decisions. Judges sometimes have difficulty seeing coercive control, and conversely, some survivors have been accused of coercive control when they were trying to protect their children from abuse, with negative consequences for their cases. I also think it's important to think about how criminalization of coercive control would impact family law and child protection cases. My second point is that we should examine whether the criminalization of coercive control and its implementation will have unintended consequences and take steps to avoid those consequences if criminalization does occur. I worked as a Crown prosecutor in the 1990s and witnessed firsthand how mandatory charging and prosecution policies led to mutual charges in domestic violence cases, where police would charge both parties and leave it up to the judge to sort it out. Based on this and other experiences with criminalization, we must ensure that survivors of violence are not caught by new laws on coercive control. As Professor Benedet mentioned, we know that women continue to be subjected to myths and stereotypes about their credibility when they make allegations of domestic violence, and we need to ensure that that isn't used against them, either by abusers or by the legal system itself. It's also crucial that we think about how criminalization disproportionately affects Indigenous and racialized people. Criminalization of coercive control may also affect the willingness of survivors to call the police for immediate safety needs, which we already know to be an issue for these and other groups, such as migrant women and LGBTQ+ folks. We cannot call these consequences unintended or anticipated anymore and must think about them in the context of criminalizing coercive control. My third point, and I'll be brief here, is that we should fully consider the experiences of other jurisdictions with the criminalization of coercive control, looking again, not just at law on the books, but also how their laws have worked on the ground. And I also think it's important to look at those jurisdictions that have decided not to criminalize coercive control. Experience from those other jurisdictions shows that if a new criminal law is passed, it must be accompanied by specific police and Crown policies, along with training, not just for police and Crown, but judges and lawyers more broadly, as well as supports for survivors. And my overarching recommendation is that whether to criminalize coercive control should be examined in the context of a national action plan on violence against women. We know that WAGE is moving forward with this sort of action plan. Consultations will be happening across the country. And I believe it's important to think about how the criminalization of coercive control will intersect with the other kinds of recommendations that WAGE will be bringing forward, and that justice has an important role to play here.
Thank you. Thank you very much. We'll now go to Hiatus House, represented by Genevieve Ishaq. Please go ahead for 5 minutes.
Thank you, everyone. As the Clinical Director of Residential and Community Services at Hiatus House in Windsor, Essex, Ontario, I really appreciate the opportunity to speak with all of you with respect to Bill C-247. Our mission at Hiatus House is to break the cycle of domestic violence, one family at a time, by providing 24-hour crisis help and emergency shelter to abused women and their children, combined with public education, research, and specialized counseling services for all family members impacted by domestic violence. We know that 1 in 4 women have reported that they've experienced domestic violence. Because this does not include the unreported instances, we believe this number is closer to 1 in 3, similar to what the World Health Organization reports worldwide. Keeping these numbers in mind, I would like to ask you to just consider how many of you know or have known of a family member, neighbor, coworker, or friend who's experienced domestic violence. And should one of these women in your life ever need assistance, Hiatus House is the only shelter for women experiencing domestic violence in Windsor, Essex. Amidst the current pandemic, we know that survivors of gender-based violence are most at risk of violence in their own homes. We know that the most common location of abuse for women and their children is in their home. We hear the necessary pandemic messaging of staying home is staying safe, but what happens when home isn't a safe place to begin? Being coerced to stay home results in feeling even more isolated, leaving them with little opportunity for escaping their abuser and finding safety. Abusive partners use isolation, both physical as well as psychological, as a means to control their partner's contact with friends and family, to emotionally bind the partner to them with the shackles of fear, dependency, and coercive tactics of control. We know that the risk to women in abusive relationships is dynamic and that these women are subject to isolation, emotional and psychological abuse, and controlling acts of violence. This abuse invariably escalates over time, and these abusive behaviors are intended to cause fear and gain power and control over a woman's thoughts, beliefs, and actions. Controlling another person's thoughts, beliefs, and actions does not require specific overt acts of violence, although those acts certainly may be occurring as well. As such, this bill will help keep women safe and hold abusive partners accountable for their violence, whether that violence is an overt act of violence or the types of emotional and psychological abuse that is most common in intimate abusive relationships that I have just detailed. Our interests in this bill are focused on the safety of women subjected to gender-based violence, including intimate partner abuse, and the eradication of all forms of gender-based violence. We are grateful for the possibilities that this bill offers and commend MP Garrison for his initiative in bringing this critical piece of legislation forward. As you are all well aware, the question of finding the most appropriate criminal response to intimate partner abuse has challenged the violence against women movement, politicians, policymakers, and shelters for decades. While we think Bill C-247 offers important ideas, we believe it's imperative to also take the time for fulsome and inclusive discussion about integrated legal responses before committing to just one approach. We believe the National Action Plan on Violence Against Women, currently in development, is important to consider. Such an inclusive discussion would ensure that unintended negative consequences as well as positive benefits of any law or policy reforms are carefully considered and appropriate and adequate resources are put into place to support these reforms. So we urge you to create space for these diverse voices when the Standing Committee on Justice and Human Rights examines this bill. We also offer our input at any time it may be helpful. Our expertise and experience over many decades working with women with diverse experiences of violence has taught us much in the implementation. We concur with the intent of this bill and value its genesis in the context of COVID-19 related surges in intimate partner violence. With that, I thank this committee for inviting my opinion on behalf of Hiatus House today. I hope that you will consider providing careful study and adequate resources to effectively and appropriately implement this bill and allow it to accomplish its well-intended goals. An end to violence against women and their children in Windsor, Essex County and across all of Canada, creating a life where all family members are empowered to live violence-free is our vision for the future. Thank you.
Thank you very much, Mrs. Huck. We'll go into our first round of questions. The first round will consist of 6 minutes. We'll start with Mr. Lewis. Go ahead, sir. You have 6 minutes.
Thank you, Madam Chair, very much. And thank you to all the witnesses for this very important testimony. We certainly appreciate all the information and dialogue. Of course, and I guess specifically Greedy, perhaps, I really want to thank Ms. Ishik for coming on this as well today. Thank you for all you do for Windsor, Essex. It's very, very important. And as you had mentioned in your opening remarks, there's probably not many of us, unfortunately, that don't know somebody that has reached out for your to those types of services. So thank you very much to all of you. Specific to Ms. Ishik, can you comment on the impact of COVID-19 on instances of domestic violence over the past year? And are there recommendations you have on how the government can ensure better support is provided to survivors?
Thank you so much for the question. And so what I can tell you, certainly in Windsor, Essex, what we saw initially during the first phase of COVID, it was actually quiet in terms of our crisis calls, our women who were reaching out, accessing shelter, wanting to access shelter. It was actually very quiet to the point where it was scary that they weren't reaching out. And I think that was because there were so many unknowns, right? And the fear and the fact that they, are being told to stay at home and not knowing what's happening with COVID and the mixed messaging. So, but what we did notice is once the restrictions started to lift, we did see a surge in calls and a surge in women accessing our shelter, but also all of our outreach services. Obviously, we had to suspend some of our outreach services in person, but we continue to provide those virtually. But our shelter has been open, and we continue. The problem we're encountering is capacity. We are, as you know, population-wise, we do not have enough beds to adequately accommodate women and children accessing. We have 42 beds for all of Windsor, Essex County, and we do not have enough beds. We did have to, the provincial government did help us with accessing a hotel. But at one point, pre-COVID, we were actually turning women away because we didn't have beds. So, our population, and this is where you can help me, it's together with Windsor, Essex County, it's over 400,000. So, and when you look at the stats, so we are so underserviced, and I know we're not the only community. And so, I really, I urge, every community, all politicians and the government to provide more resources, not just for shelters and community-based services, but for all services, because there just isn't enough to meet the demand. We do everything, we safety plan with every woman, but we cannot always provide adequate shelter space for them. I hope I've answered your questions.
You certainly have. Thank you. Thank you for that answer. That was a very good answer. Again, through you, Madam Chair, to the same witness. So you had mentioned in your opening remarks, 1 in 4 women, but you believe it to be closer to 1 in 3 women. And on that same tone then, because I was wondering before this meeting, you actually answered my question, but it takes me down another path. Because if we indeed have a lot of couples now at home, would you suggest that perhaps that number could even be closer to 1 in 2? I guess is the first part of the question. And the second part of the question is, have you seen a change in the type of violence, the type of domestic violence during COVID-19? So be it mental or be it physical. I'm very curious on that front. Thank you.
Mm-hmm. Our experience, and I've been working in this field and with women, really, I learned from the women with lived experiences. And what I can tell you is that I've been in this field for actually 22 years. I used to work in London and now in Windsor and Essex County, is that we know that initially the violence starts off very subtly. We see the isolation, we see the psychological abuse, and over time it does escalate. What I can tell you is with COVID-19, that has in some situations escalated the severity. We are seeing, the severity of some of the clients in terms of the risk. We're seeing many more threats to kill, threats to harm. I don't know what the criminal stats are in terms of convictions and charges, but we have seen an increase the last little while in terms of the severity. I mean, it's always been there. I think, violence against women and those severe cases and the complexity, but we are seeing much more, certainly in Windsor, Essex County, in terms of the dangers, also with being across the border, being close to the border, we are also seeing many more cases of human trafficking. So that's Excellent. Something that we never used to see.
thank you so much. I know that my time is up, so I
Thank
want to
you.
say just thanks very much for coming on, and thanks for all the hard
Oh.
work you continue to do.
Thank you,
It's
Mr.
my
Lewis.
privilege. Thank you.
Thank you. We'll now go to Ms. Briere for 6 minutes. Go ahead, Madame.
Thank you, Madam Chair. Merci à toutes les trois. Thank you to all three of you for all the work you do. It's very important on this important topic. And my question can be for Ms. Koshan or for Ms. Benedette. Mrs. Koshan, I'd like to congratulate you for the prize that you won last year.
So we know that conjugal violence is taking on many different forms nowadays. Power and control over an intimate partner are the central focus of the dynamics of this violence. Think about cyber violence, where a partner can monitor and control a spouse or even exercise harassment or stalking. This could take a form of publication of personal or intimate content about the partner as a means of vengeance or control. In your opinion, does the criminal code sufficiently cover this aspect of spousal violence, and the bill under study, could it contribute to that, to dealing with that?
For that recognition of my award, Madame Briere. I agree that cyber violence is increasingly an issue that we need to grapple with as a society. I don't have specific expertise on cyber violence. For the most part, I've been looking at provincial laws that now prevent the disclosure of intimate images and allow courts to grant injunctions and then create a tort if those images have been disclosed without the consent of the victim. But I do think that we have room to improve the way that our criminal law is addressing cyber violence as well. I wonder if I can turn it over to Professor Benedette, who's more of a criminal law expert than I am, for her thoughts on this one.
Thank you. It's a very good question. And of course, one of the realities of this kind of cyber violence is that it makes it very difficult for the woman to truly separate from her abuser. The idea of starting over in a new place or, a fresh start becomes very difficult when there are these continued ties electronically. So I do think in terms of the way that the bill is currently drafted, there's certainly no reason why coercive and controlling behavior done through electronic means couldn't be covered. It certainly could be part of the controlling or coercive conduct, but there might be value in signaling that by including the phrase including by electronic means, which we see in some other offenses in the criminal code. So that might be a useful signal that it's not just necessary. It also brings me back to the point I was alluding to in my opening remarks. I'm a little bit concerned. I understand the need to try to define this in terms of certain relationships, but the idea that people necessarily have to be part of the same household doesn't really speak always to relationships that could be quite controlling through electronic means, even where people are not resident together. So just two things to think about in that arena.
Thank you, merci. And Professor Benedette, justement sur cette question.
And on that question, Professor Benedette, on that question, we use the term tie or link, whereas in the criminal code, there is already a definition as an intimate partner. And you raised that in your introductory remarks. So sure, it can occur between spouses, but it could also be much broader than that. So my question is, the use of the term link or tie in the bill is perhaps too restrictive, and perhaps we should broaden that definition.
Concern that I had when looking at the draft legislation. I don't want to detract from the fact that most of the time that is what we're talking about. We're talking about intimate partners, and the way that this is drafted, it's not required that the spouses, common law partners, or dating partners live together. But once we get beyond that, to former spouses, and to other kinds of relatives. It seems to be, as I read this, it's required that they be members of the same household. And that seems odd to me and not really in keeping with the way that coercive control can work, even as a woman is trying to extricate herself from a relationship, or for very vulnerable victims, children, older adults who have no ability to extricate themselves or really to control someone's access, even if they're not living together. So I would encourage taking a look at that definition and maybe thinking a little bit more broadly about the kinds of relationships and situations where this behavior can occur.
En lien avec ma première question sur la cyberviolence.
In connection with my first question on cyber violence, it could also be for former spouses, and then cyber violence would be continuing to be used.
That's exactly right. And if we limit it then to former spouses who are members of the same household, that seems strange to me when you think about the ways in which cyber violence can be inflicted. Yes.
Thank you. You're out of time, Ms. Briere. My apologies.
Thank you.
Donc, we'll go now to Monsieur Fortin. Monsieur Fortin, voulez-vous commencer?
Mr. Fortin, would you like to begin for 6 minutes?
Oh, okay. Désolé.
Sorry. Hello, Madam Chair. Good morning, everyone. Thank you, witnesses, for being here today. It's an important topic that we are dealing with. And, of course, your wisdom is very important for us on this situation. I think that situations can easily get out of control, whether it's in good faith. Hearing people such as yourselves, it can enable us to avoid getting this wrong and enable us to get it right. So thank you for being there. So this morning I heard you in your testimony talking about violence against women. And of course, as you're no doubt aware, there's nobody here who's going to say it doesn't matter. We all consider it very serious and that we have to fight against it. And I think there are already legislative provisions in the Criminal Code and elsewhere which condemn violence, whether spousal violence or otherwise. And spousal violence has a pernicious side to it because the victim normally, most of the time, lives on a day-to-day basis with the perpetrator. So I would like to hear you perhaps a little bit more on the purpose of the committee. We're working on issues of behavior, controlling and coercive behavior, a concept that fits in somewhere between violence. We understand that violent acts such as assault is a criminal offense. No need to add other provisions in the criminal code that already exists. Then there's harassment, which is a criminal act already, which is already covered. And at the other extreme end of the spectrum of difficult relations, let's call it, or relationships, there are discussions between couples which can be tough or rough. It can happen that a woman might say to her better half, I'm not happy about this or happy about that. It seems like the neighbor is, the woman next door is ogling you, or there can be similar discussions between them that are not pleasant but are legal. We don't want to sanction it because it's okay to have arguments in a couple, even though sometimes they can be tougher. But the coercive and controlling part fits somewhere in between the crimes or stalking, assault, and so on, and the other side. So in this section, I have a hard time understanding what are the limits or the boundaries. So can you explain what would you consider as being, let's say, controlling behavior, but that is criminal, as compared to a controlling behavior which is not criminal? Perhaps, I don't know, Ms. Koshan, who is a professor at the University of Calgary, I'd like to hear you about that first. And if one of the other witnesses would like to add as well, I would be happy to hear from you. Thank you.
Yes, thank you very much. So I agree, this is this is an important opportunity for us to ensure we get this right. And as I raised in my opening remarks, one of my concerns, if the offense isn't drafted properly, is that actual survivors might be caught up in the criminal offense, and they may be criminalized simply for trying to protect their children. That could be seen, I suppose, on a certain level as being controlling behavior, even if they're doing it for very good reasons. So I agree that we absolutely need to get the language in the criminal code right. And this is also where in my opening remarks I talked about the importance of looking at what other jurisdictions have done. So we have in this bill adopted the model that England and Wales have put forward. One of the other models that I think is really interesting and important for the committee to look at is what Scotland has done. So they passed a law creating an offense for domestic abuse more generally, which includes coercive controlling behavior, but also includes things like physical violence, sexual violence, and harassment, and everything is encompassed within the same offense. One of my concerns with the bill, the way it's currently presented, is that it may continue to result in police laying multiple charges in cases. So they may charge an accused with coercive control, they may charge them with physical assault, with sexual assault. And if we think about a more encompassing offense that includes all of those different kinds of behavior, that might be a model to take a look at. So I'd really encourage the committee to look at how laws in other jurisdictions that have grappled with this issue have ended up being interpreted and applied by the courts, and how they've worked on the ground, because I think that'll help decide on what's best for Canada.
Est-ce que vous pourriez, en quelques mots, on n'a pas grand...
Yes, but we don't have much time. I have 6 minutes. I don't have much left, but in 30 seconds, could you give me your personal opinion? What should be allowed and what should not be allowed in terms of behavior? And never mind about assault, which is criminal.
Can I turn it over to Professor Benedet for this, because I know she has
I don't
something
think we
to
have
say
a
on
lot of
this.
time. Madame la Présidente, je vais peut-être vous demander...
Madam Chair, perhaps I could ask you to please stretch it by a minute in French.
Les problèmes de traduction.
You know, with the problems of translation, the reality of the interpretation is that we lose a bit of time. But anyway, I'll leave it up to you. Thank you.
Please.
Right. So what I would say is, of course, assault requires physical contact. The offense of criminal harassment requires that the victim fear for their safety. I think if we are thinking about a coercive control offense and it's distinct from those two kinds of offenses, it needs to focus on behavior, on a course of conduct that has the effect of maybe making somebody fear for their safety, but also creates a substantial interference with their freedom and their ability to carry out their day-to-day life. I think that's really where the focus has to be, and that's the wording that we're looking for, possibly as part of a larger offense. Yeah.
Thanks very much. Appreciate that. We'll now go on to Mr. Garrison for 6 minutes. Go ahead, sir.
Thank you very much, Madam Chair, and good morning to the witnesses, and I thank you for being with us this morning. I want to start with a couple of questions to Ms. Isaac, but first of all, let me thank her for the frontline work her organization does, and of course, that's common to all the frontline organizations across the country who work in difficult circumstances and are always under-resourced. I also thank her for the kind remarks she made in the beginning. And I do want to stress that while there is a specific bill, we're also looking in this study at other things that can be done to address this problem of intimate partner violence. In your discussion, Ms. Isaac, could you tell us how often you run across the pattern of controlling and coercive behavior in those clients who seek your services?
Very often. In fact, the common denominator is the controlling behaviors, the psychological abuse, isolation, and especially with COVID, that has just amplified it. But I would say, you know, pre-COVID and in the years that I've worked with women in abusive relationship, that is very, very common, right? From the stalking to what we're seeing now too. I didn't mention this because of time, but we're seeing the legal bullying. They're using the family court system. I can, talk all day about the cases, but the psychological, the verbal, and it's that, over and over. Their intent to really instill that fear and try to gain control over their thoughts. It's the incessant calling, the texting. So we see that very often. In fact, we see that more than the physical violence. And we know from the women, they tell us that those, effects, the psychological effects, the controlling, much more long lasting, and the psychological consequences, as we all know, are difficult to measure, but we know, and the research does support all the consequences as a result of that, walking on eggshells and really not being able to live their life fully, and now being trapped because of the stay-at-home orders, which hopefully will get lifted soon once this COVID passes.
And if I can again to Ms. Isak, how often in those cases which involve physical violence, would you say that it's preceded by coercive and controlling behavior?
Oh, like the majority, definitely the majority. We see on average, like we get about 3,000 calls a year. We see on average about 300 women, 250 kids in the shelter. And again, limited capacity. We've had to turn some women away because we're under service for our area. Yeah, I would say the majority, and our data would support that, and I think the research probably supports that too. But the researchers on this panel, I'm sure, could respond to that.
Thank you very much. To Professor Koshan, I would actually ask that you step in on that point at this time.
Sorry, could you repeat that part of the question?
Well, I was just asking about how often both coercive controlling behavior is a factor in those seeking shelter or exit from the relationship, and how often it's connected to physical violence.
Yeah, so I guess I'll try and be brief on this. From the judicial decisions that I have read, I think a real problem is that judges don't recognize coercive control, especially in the family law realm. They tend to see violence very much as an incident-based scenario, and they tend to rely much more on physical violence. And so that's why I do think a criminal code has a role to play in helping judges to actually be able to see coercive control. So that's what my research, I think, can contribute here.
Thank you very much. And Professor Benedek, on the same question, is there really a continuum that we're dealing with here of coercive controlling behavior and physical violence?
There's certainly a connection, and the two overlap. What I would, and I think Ms. Isak's comments are in this direction, what I would discourage you from thinking is that somehow coercive control is less, that it's just a step en route to physical violence, which is invariably more serious. Sometimes this behavior is so enormously degrading and harmful that it really eclipses the physical violence in terms of the woman's experience. But yes, there's absolutely a connection between the two, and it's there. It's omnipresent as the backup to any resistance to the controlling behavior.
Thanks very much. I want to go back to Ms. Isak. Certainly, the private members bill I proposed is one suggested tool for dealing with this problem of coercive controlling behavior. You talked about an integrated legal response. So very quickly, can you give me some idea of other measures that you had in mind?
So, as you know, the National Action Plan on violence against women is in, I guess currently in development. So I think, somehow, because all the systems have to work together, right? We know that there's a disconnect between the criminal court system, the family court system, the community-based, agencies. Like, we still, unfortunately, still work in silos. But I think if we have everybody working together, it's complex, but it can be done. I look at the US, they have a Violence Against Women Act. Like, you know, like there isn't enough legal consequences, but it has to be done, you know, in an integrated collaborative fashion because, you know, we have to worry about the unintended consequences.
Thank you. I'm so
Okay,
sorry, Mrs.
sorry.
Black,
No,
we're
that's
completely
okay.
out of time. We'll go to now our second round of questions, starting with Madame Finley for 5 minutes. Go ahead.
Thank you, Madam Chair, and thank you to the witnesses and for sharing your expertise here today. It's very much appreciated. I have a daughter in at UBC Law and one at U of C Law, so I ask you professors to be kind. With that, I will say that over the course of my legal career doing a lot of family law, I've dealt with all these issues, and I found the hardest thing in advising was to help women walk through their fear and find their voice again. This is a slow process. It's not a quick process because often it's been lost for a very long time. I only have 5 minutes, so I'm going to open with a couple of questions. Hope we can get through them if I get a chance to get to another one. So starting with Professor Benedette, I understand that you're a leading scholar on this topic and also active in pro bono work representing victims of sexual violence. I thank you for that work. And I understand that some of your more recent research has focused on barriers to the criminal justice system for victims of sexual assault. So can you tell us about how these existing barriers have been affected by the pandemic and what changes you would like to see to increase confidence in the justice system in the public's mind to address underreporting?
Thank you. That's a really good and complicated question in a short amount of time. But you know, the barriers that my work sort of looks at, in part, it's the unwillingness of those kind of first line of response, the police and later Crown Counsel, to actually see and to recognize the experiences of women. And this is my concern, that I think it's very useful to look at legislation and to think about strengthening the criminal code. But sometimes it gives us a bit of a false sense of security because, in fact, if you have women who won't even bother to report because they feel that they're going to be treated with contempt by the police, that their cases will not be properly investigated, that you know, there just becomes a privatization of violence against women. The idea that it's meant to be solved by women alone, perhaps in conjunction with some community supports, but that there's no state responsibility to interfere with male violence. And that's what needs to be underpinning all of this, new offenses, action plans, is that the idea is that this isn't for women to navigate on their own, that there's a state responsibility to step in and to interfere with that violence.
Thank you, Professor. To Professor Cauchon, I know that you have a forthcoming article coming out, COVID-19, the Shadow Pandemic and Access to Justice for Survivors of Domestic Violence. And in that article, you talk about increases in domestic violence cases being traced to the impact of the virus itself, as well as to societal responses to contain the virus, such as stay-at-home orders that lock women and children in homes. And listening to the testimony, I would say, or increased perpetrator access when they're at home in one place. So what services ought to be more accessible? And a question I have is the issue a true lack of availability of services or a lack of awareness of the services that are available, or both?
Thanks very much for that question. Yes, so our research does show several barriers that have arisen for victims during COVID-19. One barrier that we haven't talked about are barriers that the courts themselves have created through only hearing urgent cases, and especially in the family law area, that has really made it difficult for women to even get into court. And to echo Professor Benedette's point, that kind of results in the privatization of violence because women don't even have access to a judge who will hear their concerns about custody and access issues and how they're being impacted by COVID, for example. Something else I think we should be looking at is increased access to legal aid and other legal funded legal representation for victims. And in the context of the bill specifically, I think it's really important to think about supports for victims, including independent legal advice, because they're going to have to testify about very, very terrible traumas that have happened to them, and they will need supports to assist them in being able to do that. Thank you.
Thank you. Thank you very much, Madam.
And you see, I'm done, out of time already.
You're
Thank
great,
you.
very efficient.
So much to talk about. Thank
I
you.
understand that. We'll now go to Ms. Demoff for 5 minutes. Go ahead, Ms. Demoff.
Thank you, Chair. And I want to thank all of our witnesses for being here. And Mr. Garrison, I really want to thank you for bringing this forward and highlighting such an important issue. On January 28th, Dr. Jennifer Kagan went to court with an urgent motion to suspend access by her ex-husband to her daughter. On February 9th, 2020, little Kira Kagan was taken by her dad to Rattlesnake Point. He jumped off the cliff, killing them both. And I've had numerous meetings with Dr. Kagan and her husband, who is a lawyer in family court. And we've had several conversations about exactly this, about coercive control, about the lack of knowledge by the judicial system about intimate partner violence and particularly coercive control. So she had been trying for 3 years to convince judges what this ex-husband was like and was continually denied. And it resulted in the death of this wonderful little 4-year-old girl. So I wonder, having laws in place are one thing, but one of the things that her stepdad has expressed concerns about, because he's a lawyer in the Ontario Family Court, is that putting it in law does not solve the problem if we don't have the education. So I'm wondering, perhaps I see Ms. Coshan shaking her head and Ms. Professor Benedict, I wonder if you could just comment, not just on judges, but police and Crown, how critical that is so that we can protect little girls like Kira and women like Jennifer.
Thanks very much for that question. Yes, I absolutely agree that there needs to be judicial education around coercive control. I would say that we should be educating lawyers about coercive control as well, because one of the issues right now is that lawyers don't screen for domestic violence in family law cases. And if their client has been subject to coercive control, that can completely affect the way that the family law matter unfolds. And so I think there needs to be, even starting in law schools, education around coercive control. There also needs to be training for police and Crown prosecutors. And to go back to what I said in my opening statement, there need to be policies so that police and Crown are appropriately applying whatever law comes out of these consultations. Thank you.
Professor Benedict, did you want to comment on that? Because I know you train lawyers.
Yes, as does Professor Coshan, and I do a lot of judicial education as well. And sometimes that's right. It is about awareness and understanding that behaviors that on their own might look like either not offenses or minor offenses, things like destroying property, joint property that's owned by them, or that the spouse drives, erratically and at high speed when the wife and children are in the car. That there are recognized risk factors and patterns of behavior here, that we're not starting from zero, and that we need to be able to recognize that. We also have to name and reject the persistent stereotype that women only engage in these family court processes in order to punish dads and keep them away from their kids, as some kind of vindictive move for having been scorned. That's a pernicious stereotype. It's a myth, frankly. Women don't engage themselves in the family court system generally unless they absolutely have to. And that's part of what feeds into the denial about just how serious this behavior is.
Thank you both. Ms. Ishak, I had a question for you, and thank you for the work that you're doing. And I know it's not easy. My question for you, in speaking with women's shelters, I often hear the prevalence of how firearms are used. Not just in intimate partner violence, but for coercive control, and I wondered if you could maybe speak about your experience on that, and if there's time, maybe some others want to pipe in as well.
Yes, we do see it. We don't see it often, actually. We see more other weapons, knives, you know, like really, you know, any weapon. So I would say we see more of knives, bats, you know, sometimes boots. Like it could be anything and everything. But I would say, which is surprising, you know, so we don't see a lot of guns, but certainly it does happen. The guns that they do use, though, a lot of times it's the threats, right? Like I have you know, it could be a hunting gun. I have a gun and I'm going to, you know, threaten to kill you if you leave. I'm going to, you know, kill, you know, the horses or the dogs or, you know, whatever the pets are. So that's what we see more of.
Thank you. I think that's my time.
Thanks very much, Ms. Damafa. I will now go to Monsieur Fortin for 2.5 minutes. Sir, go ahead.
Merci, Madame la Présidente. Je vais reprendre.
Thank you, Madam Chair. I'd like to come back to my last question. Madam Ishak, you were talking about a spouse who was telling his wife, I have a gun and if you leave me, I will kill you. Is that not a threat that is already criminalized? So what does the witness think about this?
Mais vaut mieux je pose la question à un autre témoin?
Oh, never mind, because I'm going to have lost a minute. But what I'm wondering, I'd like to determine what is allowed. There are quite a few things that are not allowed, but I'm wondering what is considered unacceptable and which is not already criminal. Sequestering someone is a criminal act. At Section 279, a threat is also a criminal act. Harassment as well. Assault is a crime. It's even a crime to spit on somebody. So I'm wondering, I'm trying to explain my concern. I'm trying to determine what are we trying to forbid? What, in your opinion, is acceptable in a couple's relationship and is acceptable other than hugs? What would be acceptable? Where is the limit between the acceptable and the unacceptable?
Manifestement, ça va prendre plus que 5 minutes pour que j'aie des réponses, Madame la Présidente.
It's taking time for me to get my answers.
Yes, maybe what I can say is that we are talking here about behaviors that aren't necessarily covered by any other provision. Threatening to destroy someone's property, keeping them away from their friends. That doesn't really amount to the offense of unlawful confinement, which requires physical restraint of the person. It's a kind of psychological terror and punishment that has the effect of restricting people's day-to-day lives in a way that doesn't necessarily involve overt threats of violence or overt physical force. So that's the line that's trying to be drawn. I recognize that it needs careful drafting.
Est-ce que ça passera pas davantage par l'éducation?
Would it not go through the education of youth?
We are running a little bit behind also. We'll turn to Mr. Garrison now for 2.5 minutes. Go ahead, sir.
Thank you very much, Madam Chair. I'd like to give each of the witnesses maybe 30 seconds to respond just very directly to the question. Do you think an initiative like criminalizing coercive and controlling behavior is a useful contribution to a strategy of confronting the very high levels of physical violence between intimate partners in this country? Maybe we'll start in the order that they testified. So, Ms. Ishak.
Mrs. Huck, I think we'll go to you first for that. You're on mute, madam.
Oh, sorry about that. Absolutely. It's at the end of the day, I think for me, it's an opportunity, to legalize, behavior, and it's behavior, that is obviously unacceptable. It's abusive, and we believe that any learned abusive behavior can be unlearned, but this is one way to hold the abusive person accountable. But coupled with that, there needs to be training and counseling services for all family members who are impacted by domestic violence, including the abusive person, because if we know that if you provide help to him, we know that behavior can change, and that will make a difference, I think. So it's all of it. Thank you. Oh, I have 1 minute.
If I could just 1 minute.
Oh, sorry.
If we could just interrupt, maybe I'd like to give 30 seconds to each of the other witnesses to respond to this. So perhaps Professor Benedict?
I'd say there are two big benefits. The first is that it permits early intervention because it allows people like neighbors and friends to go to the police with information, and it's a basis for for the police to actually do something. He's taken the tires off the car and won't let her go anywhere. It's that sort of thing. The other thing is that it names and makes visible a behavior that sometimes is treated as not really anything because it hasn't escalated to violence. So it has those two benefits, is what I would say.
And with the indulgence of the chair, perhaps Ms. Cauchon, just very briefly.
Very briefly.
Yes, thank you. So I agree that criminalization of coercive control can have the kinds of benefits that my colleagues have mentioned, but I would really urge the committee to ensure that it's done correctly so that the offense doesn't have unintended consequences or impacts on members of marginalized groups, and that it fits within the overall scheme of laws that we have in Canada.
Thank you very much for that. Now, with the consent of members, we do have Mr. Moore and Mr. Sarai for 5 minutes each on the list. Is it okay if we finish this round before we go to our second panel? I'll see a thumbs up. Ms. Finley, you have your hand raised.
Yes, Madam Chair. I just wanted to know if I could ask that Professor Cauchon's article, COVID-19, the Shadow Pandemic, and Access to Justice for Survivors of Domestic Violence, be tabled with the committee because it's squarely on point to what we're studying, and I did bring it up in my questions.
Thank you. Appreciate that, and I would ask the professor if you can share that with the committee. That would be really helpful for our deliberations. So we'll go to Mr. Moore then for 5 minutes. Is that okay with everyone?
Madam Chair, providing
yes.
that we are not cutting our next panel short as well.
It's a give and take, right? I know
whether... Well, I would not agree if we were going to cut the next panel short.
Okay.
Yeah, Madam Chair, thank you. Seeing the time as 1:07 Atlantic here, I would think that we should probably go to the next panel. I'm prepared to ask a question to the next panel, but I do appreciate all the time and the testimony from this panel, but we've kind of divided our questions up based on the 1 hour for each panel.
Thank you. I appreciate that. So given that we don't have consensus, I'd like to thank the witnesses for your testimony in this hour, and we'll suspend as we move on to our second panel. Thank you, everyone, very, very much. Thank you. Just very quickly before I introduce the witnesses, for all of the witnesses' benefit, before speaking, wait until I recognize you by name. When you are speaking, please unmute yourself and then mute yourself once you are done speaking. And that obviously applies to all members as well. Address all of your comments through the chair. And interpretation is available at the bottom of the screen. So please select the language that you would like to hear. When you're speaking, speak slowly and clearly, unlike what I'm doing right now. And when you're not speaking, your microphone should be on mute. I'd like to welcome our witnesses. We have Carmen Gill, who is suffering some technical challenges right now from the Department of Sociology from the University of New Brunswick. We also have the Office of the Federal Ombudsperson for Victims of Crime, represented by Heidi Illingsworth. And then we have SAGES, a Domestic Violence Prevention Society, represented by Andrea Silverstone, who is the Executive Director. At this time, we'll turn to Ms. Illingworth for your opening remarks for 5 minutes. Know that I will give you cues of 1 minute and 30 seconds to members and witnesses as you grapple with the timing. So with that, Ms. Illingworth, please go ahead for 5 minutes.
Thank you. Merci, Madame la Présidente, de m'avoir.
Thank you, Madam Chair, for having invited me today.
Person for victims of crime, and my office is an independent arm's length organization within the Department of Justice Canada. We work with victims by taking and reviewing their complaints and making recommendations to federal decision makers to ensure that victims are treated fairly and with respect across the criminal justice system. I want to pay my respects to the First Nations, Métis, and Inuit ancestors, and affirm my office's commitment to respectful relationships with one another and this land. I would like to begin by thanking the Honorable Member Randall Garrison for his efforts to bring awareness to the issue of coercive control in Canada. I do appreciate that the subject is very meaningful to him personally. In fact, my office commissioned a paper on this subject last spring, and then I wrote to the Minister of Justice to request that he introduce such legislation. This is because at my office, we hear regularly from survivors of intimate partner violence who feel that they are not heard, believed, or treated fairly when they report their experiences to the police. That is why, in my view, there is a need for legislation to criminalize coercive control, which is a pervasive form of psychological violence. Briefly, coercive control consists of repeated behaviors that aim to isolate and intimidate an intimate partner. These behaviors can include limiting the victim's freedom, verbal abuse, and threats of harm to the victim, their child, or pet. Currently, IPV is approached as an incident-based problem, and it is treated as episodic or a one-time event. And the repetitive dynamics of coercive control are not recognized. And this makes it extremely difficult for law enforcement to intervene effectively. Experts have identified coercive control and the behaviors as important precursors for femicide worldwide. This harmful and dangerous behavior has been criminalized in other jurisdictions, such as England and Wales, Ireland, Scotland, and several American states. As you undertake this study, it is important to consult with diverse experts who serve survivors on the front lines. And it's also critical to apply a GBA plus analysis and hear the lived experiences of survivors, especially those from Indigenous communities, Black people, people of color, individuals with disabilities, and members of the 2S LGBTQIA community to ensure diverse voices are considered. The following data shows us how prevalent intimate partner violence is in Canada. In 2020, between January and September, the Calgary Police Service responded to 15,038 domestic incidents. This is 55 calls a day in a city with a population of approximately 1.5 million. In Winnipeg, a city with some 817,000 residents, they typically record 16,000 domestic incidents a year. That's 44 per day. Statistics show us that intimate partner violence victims are disproportionately female. And we also know that this plagues our society and costs us billions of dollars every year. So, honorable members, I put this to you, it has to stop. This is why I support the study of this legislation. Several provisions of Bill C-247 bring positive change for victims, and I especially welcome the proposed broad definitions and the concept of connection found in Section 3. We are submitting a written submission as well, which will address some of these issues more fulsomely. But I would like to say in closing, honorable members, that I believe the Canadian legal and justice systems must be more responsive to the lived realities of victims and survivors. And in my work directly with survivors, that's why I think it is time that we address this gap. Victims deserve access to justice, which is often not possible due to our limited legislative framework. And by making criminal code amendments, we can improve women and children's safety. And we must also take the time to address current police limitations in recognizing these coercive and controlling behaviors. I welcome the opportunity to answer your questions. Thank you. Merci.
Thank you. Thank you very much, Ms. Illingworth. We'll now turn to Andrea Silverstone for 5 minutes. Go ahead.
Thank you so much. Good afternoon, Ms. Khalid and members of the Justice Committee. Thank you for having me today and for providing me with the opportunity to discuss a topic I'm incredibly passionate about: coercive control as a framework for understanding and addressing violence. I'm the Executive Director of Say Just Domestic Violence Prevention Society, which is a provincial organization in Alberta that supports individuals, organizations, and communities to disrupt the structures of violence. I'm also a graduate student at the University of Salford in Manchester, United Kingdom, working towards my completion of my master's in the psychology of coercive control. Coercive control is a pattern of behavior that seeks to strip away a person's freedom, their sense of self. It is a liberty crime. Focusing on coercive control as a criminal offense is crucially important in devising measurements of criminality because it reflects the multiple tactics of coercion and control employed by perpetrators of violence. The current framework of criminal offense does not reflect the experiences of victimization or the harm perpetrated to victims of domestic violence. This is evidenced by high attrition rates, sentencing data, and low conviction rates in cases of domestic violence. Relationships with coercive control result in greater injury to the victim and are characterized by more frequent and severe violence that's less likely to desist. The increase in severity makes the need for legal intervention in cases of coercive control even more imperative in order to interrupt the escalation and frequency of abuse. Because the current criminal framework to address domestic violence does not take into account coercive control, the justice system is not viewed by many victims or victims' advocates as a tool to address domestic violence in society. This is evident not only through the low conviction rates and high attrition rates I already mentioned, but through the fact that less than a quarter of victims of domestic violence report to the police. It should be noted that when the justice system in the United Kingdom changed their working definition of domestic violence, years before the legal system changed to make coercive control a criminal offense, calls to the police increased by 31%. This is because once the definition changed to encompass the true experience of the severity of coercive control, victims believed that the abuse they were experiencing would be addressed by the police and by extension the courts. Because our current criminal justice system focuses only on events that are deemed criminal offenses, it ends up excluding many other threats that make up ongoing coercive control, blinding the justice system and leaving it without the tools to actually address violence in our society. I've been working in the domestic violence sector for over 20 years, and I believe that including coercive control as a criminal offense is a game changer. It's going to give the justice system the opportunity to intervene in violence before it escalates. Coercive control is present in 95% of relationships where there's domestic violence. It's one of the best indicators of lethality. If the police and justice system have the ability to address coercive and controlling behavior criminally, it's going to allow them to prevent the escalation of domestic violence. It'll change how society views domestic violence. If our justice system puts the lens of coercive control on domestic violence, it will create a discourse in the public in which all Canadians will understand that violence is much more than a black eye and that people stay in violent relationships because of a loss of personal agency. It will destigmatize domestic violence, allowing us as a society to do a better job of addressing violence. It will save our system of care, nonprofit agencies, police, health, and businesses money. It's way more economical to intervene before the domestic abuse becomes physical. It allows perpetrators to get support before the lethality of their crime increases. It breaks the stigma around domestic violence, allowing both victims and perpetrators to get support. Domestic violence is at epidemic rates in Canada, and it's rapidly increasing due to the effects of COVID. We need to improve and innovate our approaches to addressing and stopping the violence before it escalates. Making coercive control a criminal offense in Canada is our opportunity to do this. I'd like to end by making 4 recommendations. The first is that we immediately implement a new nationwide working definition of domestic violence to reflect coercive and controlling behavior. My second is that the Canadian criminal law should be changed to reflect the criminality of coercive and controlling behavior. The third is that support should be provided for nationwide training for police, judges, and Crown prosecutors on the framework of coercive control and domestic violence. And my last is that we should appoint a Coercive Control and Abuse Commissioner for Canada with expertise in all forms of abuse to provide public leadership, expertise to legislators about abuse issues, and play a key role in overseeing and monitoring the provision of abuse responses with a focus on coercive control. I want to take this opportunity to thank Mr. Garrison for bringing forward his private members bill and bringing attention to this issue. And I want to thank you to the committee for allowing me the opportunity to present to you today on an issue that is so important to me and for all Canadians. I look forward to the opportunity to answer any questions and to continue this dialogue.
Thank you very much, Ms. Silverstone. We'll now go to Carmen Gill, Professor, Department of Sociology in the University of New Brunswick. You have 5 minutes. Go ahead.
Thank you. I am really happy to be here before you to share my position about the criminalization of coercive control. I prepared a brief that I don't know if you have it with you, but I will refer to the document I already submitted yesterday. It's clear that intimate partner violence encompasses different forms of violence that are physical and non-physical. However, from a criminal justice perspective, it is difficult to recognize certain behavior as being part of an intimate partner violence dynamic. And it is the case with coercive control that does not necessarily involve physical violence or a single incident, but instead consists of repeated and continuous patterns of behavior that occur over a lengthy period of time. Since we're not covering this particular form of behavior in the Criminal Code of Canada, it's completely hidden from the criminal justice system response. Intimate partner violence is multidimensional in nature and will encompass numerous forms of violence. So here I would like to talk a little bit about what is coercive control and the difficulty to address coercive control from a law perspective, law enforcement perspective. So coercive control is encompassed of both acts of coercion and control through the use of force, deprivation, humiliation, intimidation, exploitation, isolation, and domination. A number of behavior that we are going to see in coercive control seems to be normal. But if you combine all those behaviors together, they become part of what we call coercive control in a dynamic of intimate partner violence. This is done to produce a victim's obedience, ultimately eliminating their sense of freedom in the relationship, something that Evan Starts have referred to the entrapment of women in their relationship. This form of violence is continuous and resulting harm are cumulative over time, therefore unable to be explained by a single event. The intent is to remove the victim's sense of individuality, autonomy, liberty, and capacity to make decisions for themselves, effectively trapping them in their own personal lives. It's about micro-regulation that is going to be associated with traditional gender roles and the division of labor in which women are stereotypically more passive, dependent, and respond for household and childcare duty. In this type of pattern, it's going to be emphasized that the traditional role of masculinity will, where men are going to have the responsibility to pursue female partner, and general physical advantage that men hold over women, result in the unlikelihood that a woman would be able to achieve the same kind of dominance over her male partner that would be reflective of coercive control. There are numerous tactics that we can highlight about coercive control. Of course, there's physical violence, sexual violence, but there is as well tactics that are going to include limiting transportation, denying access to household, controlling food consumption, disconnecting phone lines, breaking cell phones, preventing them from going to work or going to school. If you accumulate all those forms of behavior combined together, they are going to fall under coercive control. In Canada, the Government of Canada recognizes coercive control in various documents, but it has not been translated into an offense in the criminal code. So what I would like to go for here is talk about the police response to coercive control. Police have the responsibility to assess and manage the risks that cause an intimate partner perpetrator. And of course, they are going to assess those situations in light of the tools that are offered to them. The tools that they have are risk assessment tools, and of course, the Criminal Code of Canada. Without having an offense about coercive control, they are unlikely going to see certain behavior as part of the dynamic of intimate partner violence. And it's going to be hidden because they are going to look for the one incident and they are going to look for evidence of physical violence. So I will stop here because I already spoke too much.
You're right on time, Professor Gill. I appreciate that. Thank you. We'll go into our first round of questions for 6 minutes. Mr. Moore, go ahead, sir.
Thank you, Madam Chair, and thank you to our witnesses on this panel for your expertise in this area. And I know, Dr. Gill, that you've written extensively on this. Hello from a fellow New Brunswicker. And just to get right into the question, I know that time flies in this format, but you had talked to CBC last May about the unique situation we're in now. Persons living in an environment where they're suffering domestic violence, but now we're being told stay home and stay safe. And in Nova Scotia, they say stay the blazes home. That's their slogan. So we're all being told to stay home and it's safe at home. But you've touched on this, that governments are telling Canadians the safest place for them is in their homes. But for individuals in an abusive relationship, that's certainly not the case. Can you comment? I know we're having a broader discussion around this bill, but I think one of the reasons we're studying it right now is in this context of COVID. Could you comment on what you're seeing in your research over the last year with lockdowns and people spending more time at their home due to COVID?
Thank you for this question. And this is true that I've been speaking a lot about coercive control during the pandemic. I've been saying that the most dangerous place for women is their own home. We are more likely to be victimized from someone that we know, basically from our home, a spouse, or somebody else within the home. But when you are in an abusive relationship, and you have no possibility to get out, you are completely confined in the home. And when we talk about coercive control, we're talking about being confined. We're talking about isolating. This is the perfect context in which an abuser can really control his partner, because there is no way that you can get out of your house. And especially when we were all locked down in March and April, where there was no possibilities to reach out, it was extremely difficult for those that were in abusive relationship. It's providing the perfect context for abusers who are already controlling their spouses when this is not during a pandemic. But during the pandemic, it's going to be exacerbated because they are going to be clearly on them constantly.
Thank you, Dr. Gill. And to you again, I think it's been mentioned with earlier panels on Tuesday as well as today about the challenge where police are often looking for that one incident that is chargeable, something that's clearly within the parameters of our criminal code. And you said something in your remarks that I'd like for you to elaborate on, because I think there is a struggle around nailing down what exactly it is we're talking about and when something becomes coercive control. And you mentioned that it can seem to be normal, but the cumulative effect is coercive control. So can you give some examples of that? Because we know that you know, in the family relationship, there's all kinds of dynamics that go into play. So how is something that can be normal and maybe non-criminal in one context the cumulative effect, and this gets into the difficulty of charging someone under the criminal code, that the cumulative effect could be coercive control?
Another excellent question. I'm working with police forces right now across Canada, and I give them scenarios. I'm hosting workshops with police forces, and I'm doing this across Canada, and I'm giving them scenarios where it's a story about a man and a woman who are in a relationship, and there's different things happening, not necessarily physical violence, but accumulation of different situation that are going to end up having a tremendous impact on the person who is controlled. The person is going to be controlled in their daily activities. They are going to be prevented from doing certain things. But when you present this to police officers, they're going to tell you, but what am I supposed to do with this? I know this is part of violence, but there is no offenses in the criminal code that would allow me to pursue charges in this particular situation. So basically, police officers are responding to a domestic dispute call. They show up in the residence. What they have to do is they have to determine, is this domestic, is this intimate partner violence, or is this just an argument between two adults? How do they do that? They look at the tools they have. They look at the criminal code, the offenses they have with them, and the risk assessment tools that they can use. Unfortunately, they can only assess what is providing physical evidence. So if you look at the Home Office in England and Wales, they have developed a whole series of behavior that are going to be encompassed under coercive control. And they're using as well for police in England a particular assessment tool that is going to look at different forms of behavior that are going to be combined, be considered coercive control. I know it's an abstraction when we talk about coercive control, but it's real. People are victimized. People are dying because of coercive control, because women are killed because they are under control from a partner. And I can talk longer about that.
Thank you, Doctor. I think my time's up. Is that what
Absolutely,
my chair is saying? Okay, thank you.
Mr. Moore. I will now go to Mr. Virani for 6 minutes. Go ahead, sir.
Thank you very much. Thank you to all of the witnesses for really your insights and all of the work and the advocacy you're doing. That goes without saying. This is a really, really important study. I just want to put out a comment and then ask maybe 2 questions, possibly 3. The first is that I think there's been some steps that have been made in the right direction towards the training piece. With Bill C-3 on the judicial sensitization towards sexual assault law, I think that's a step in the right direction. All of us know that the definition of family violence in the Divorce Act has been coupled with training that's being put out by the Department of Justice for public legal education and information materials and for legal advisors. So those are important steps in the right direction. The message I'm getting is that we need a lot more of that. I had a couple of questions. I'm going to start with Ms. Illingsworth, and thank you for your letter to Minister Lametti, sort of asking for this to be addressed. But the question that I have relates to what we heard in the last hour, and you heard that your testimony just now and your letter talks a lot about intimate partner violence, and no doubt that is at the crux of what we're talking about here. But some of the testimony we heard just in the previous hour also talked about women who are often on the blunt end of this kind of control, but who aren't maybe necessarily in an intimate relationship, but might be an aunt, a mother, a grandmother, a niece, and having relationships that are controlling but don't have that nexus of intimacy. So I'm wondering, how can we ensure that whatever we do is comprehensive enough to ensure that it's dealing with coercive control that deals with intimate relationships, but not to the exclusion of some of those other relationships? So Ms. Illingsworth, could you try and tackle that in maybe about 90 seconds? Thanks.
Sure, I can try. I do think we have to be careful in our definitions. The proposed bill has the concept of, close relationships and not just like it encompasses family members who may not be in an intimate relationship. So I think that's something that has to be considered, as you suggest, perhaps with aunts or mothers, that sort of thing, that may be experiencing this as well. But yeah, we have to examine this carefully and look at what the lived realities of people are. And that's why it's so important to keep hearing from those experts on the front line, like Andrea, who are responding to this every day, and who is coming to them for assistance, who is experiencing the bulk of coercive control in relationships. Is it spousal relationships? We know that a lot of coercive control happens in dating relationships as well. So that can't be overlooked, and same-sex relationships as well. So we have to look at all of these contexts, and if we're creating a law, it has to be able to respond to the Canadian context and what we're seeing all across the country.
Okay, thank you, Ms. Illingworth. And I'm going to pivot from there to the next question, which relates to something you mentioned, and Ms. Silverstone, if you could jump in. And we heard this in the last hour as well about the disproportionate impact of this on persons who are racialized, people who are Indigenous, etc. Can you try and tackle it from both ends based on your experience? So I want to know about the prevalence of this amongst Black, people of color, Indigenous, particularly women, the prevalence of this kind of control. But I also want to hear a little bit from your perspectives about some inhibitions there might be given the overrepresentation of Black and Indigenous people in particular in the criminal justice system. Might there be some reluctance on the part of women in those communities to come forward because the men from those communities are already overrepresented? It's a tough issue, but if I could have your thoughts on that, perhaps Ms. Silverstone first and then Ms. Illingworth. Thank you.
Sure, that's a great question, and one I think we have to be really sensitive in answering to make sure that people have equitable access to whatever it is, whatever solutions we put out there around addressing domestic violence. And I think it's important to note actually that coercive control doesn't just relate to domestic violence, it relates to all forms of violence, which I think is of particular importance when looking at marginalized communities, such as people who are from equity-seeking groups, because often the violence that happens in those communities is lateral violence, not just intimate partner violence, and coercive control is also something that can be laid over those communities. And I think that the more that we through our legislation, represent the experiences of people who experience violence, the more likely they're going to be to reach out to the system to get support because they will see themselves in the system. And so if we don't just limit it to, spousal violence, intimate partner violence, even domestic violence, but understand that lateral violence that does exist in different types of communities, I think that we're more likely to get the outcome we want of people from marginalized communities feeling that they can come forward. Having said that, we as Canada can always do better, I think, as a country in making sure that our marginalized communities feel like we as a country and our systems are there to serve them.
Thank you. Ms. Illingworth, did you want to respond to that question, second question, Maud?
Yeah, I would thank you. I would just agree with Andrea. We have to look at how what is the response of the criminal justice system to these communities. Traditionally, it hasn't been positive. They are disbelieved. They are the violence they've experienced is minimized. The response of police and criminal justice has not been positive. So very likely people are not going to reach out. So we have to consider this when we're developing these programs. We have to, and legislation, we have to figure out how can we provide a response that will be a criminal law response when a person wants that, but then also that they have the support necessary to get through this if they don't want a criminal law response, if they don't want to go that route.
Thank you.
Thanks
very much, Mr. Virani. We'll now go on to Monsieur Fortin. Voulez-vous commencer pour 6?
Would you like to begin now, sir, for 6 minutes? Thank you, Madam Chair. Thank you, all the witnesses who are here today. I think that your testimony is important. This is a delicate topic that we're examining now. And as I said earlier, in my opinion, there are many pitfalls, and we have to be cautious in the way we approach these situations. And your wisdom on this is very valuable. So, Ms. Gill, I would like to ask you, I appreciated part of your testimony when you said, well, you're helping me to get a better idea of what has to be handled in the course of our deliberations. I understand that there are already crimes defined for violence, assault, harassment, forcible confinement, threats. All of those things are already subject to criminal prohibition and prosecution when incidents like that occur. And on the other extremity of the spectrum, there are behaviors with relationships in couples that are sometimes stormy, but nevertheless are acceptable, and in a normal society we have to allow. So are we in between the two when we talk about coercive behavior and controlling behavior? And what I understand from your testimony, Ms. Gill, and other testimonies before that is that we're trying to find a kind of a pattern in order to determine what will be a controlling and coercive and reprehensible behavior that we want to avoid. So in the preamble to my question, I would like to know, am I right if I say that it's part of the pattern in a repeated pattern of events of a controlling and coercive type that we're going to find what we want to avoid? And the second question will be, is it really necessary to make a criminal offense of it? Or in your opinion, are there other ways to better fight against this type of harmful behavior that harms everyone's life, actually?
Excellent question, merci.
Your questions are excellent. Thank you. I agree with you. There are several offenses in the criminal code which allow us to speak to different forms of violence. However, when it comes to coercive and controlling behavior, and we want to make it an offense, we have to change our paradigm in regards to the way we treat domestic violence within the criminal justice system. What I mean is that when we look at behaviors, physical, violent behaviors, we usually focus on one incident. We'll look at one incident and we'll keep the offense to that incident. In my head, I'm speaking English, and now I'm speaking to you in French. Your French is excellent. It's wonderful for me. We're going to lose a bit less time. So what happens is that we're focusing on one incident. In regards to coercive and controlling behaviors, it's not just one incident, it's the overall situation. So if we criminalize these behaviors, it will force us to look at domestic violence in all its complexity. Isn't there a danger of making an offense of behaviors which we might say are okay? That couple, they raised their voices. The wife didn't want her husband to go hunting, and she hid the keys, for example, for the car. There are some extreme behaviors which we believe are acceptable. So we don't want to criminalize that. So where do you draw the line? How can we sort out what is criminal and what is just a little heated but acceptable? So we'll agree on the fact that two adults who have an argument, who quarrel, is not a criminal code offense. However, if you start to see that there's a accumulation of behaviors within a relationship, it could become a criminal code offense. It's obvious that if you think that it's normal that a man in a relationship makes the major decisions, financially, for example, or that, the wife leaves work to take care of the kids, there are several behaviors that will associate to the traditional masculine and feminine roles, which we might see as completely normal. However, it is within those behaviors, within those roles, that some people will start to take control over someone else. And as I said, in the Home Office statutory framework in England, they've put together different situations that represent coercive and controlling behaviors. When police intervenes, they're not just looking at one incident. They'll ask themselves, what's going on in that situation? It must not be easy for the policeman. I'm sorry, I don't want to be impolite. We have very little time left. We have 30 seconds left. Are there other ways to avoid unwanted situations? Is there another way to go other than a criminal offense? We have to be efficient at all levels. And I could say that it starts with the criminal code, because if we criminalize these kinds of behaviors, it will have an effect on other sectors. It's going to raise awareness in all the population on behaviors which we need to live with and that we can't say are criminal. Thank you. We'll come back to that. Thank you.
We'll now go to Mr. Garrison for 6 minutes. Go ahead, sir.
Thank you very much, Madam Chair, and I want to express my thanks to the witnesses for being here today and also for their kind words. And the Victims Ombudsman made reference to my personal situation. I just want to say that I did grow up in a family where coercive and controlling behavior many years ago was seen as the rule and the normality. And unfortunately, I think what we're finding in these hearings that it's still quite often seen as natural or the rule that should apply in families. But my reason for bringing this forward really is the direct response to the many women who have reached out during COVID for assistance and help as the already existing problem of intimate partner violence, domestic violence, and coercive and controlling behavior has become worse during the pandemic as access to services have been more restricted. I want to go to Ms. Silverstone. She talked about people staying in abusive relationships because of the loss of independence and how that's related to coercive and controlling behavior. And maybe she could just tell us a bit more in her experience in the organization she works with about the significance of the loss of independence.
Sure, thank you so much. I'd be happy to talk about that. So I think that what's most important to recognize about coercive control is that it's a pattern of behavior that is low level, repetitive, often doesn't involve physical violence, and takes away a person's sense of personal agency, and they no longer make decisions based on what their own best interests are or what their driving motivators are, but they make decisions based on fear of what the other person in the relationship is going to do to them if they don't make a decision in a certain way. And so I actually think that the questions that were just asked to Carmen are really pertinent questions also in relation to that loss of personal agency, because when a couple fights, if neither one of them changes their behavior as a result of the fight, it's not coercive control. What it is mutually conflicted relationship. But if one of the parties starts to change their behavior, lose their personal agency, lose decision-making that is in their own best interest, where their identity becomes subsumed by the other individual's identity, that is actually how we define coercive control. There's a wealth of research that around identity theories and how coercive control actually takes away a person's identity, and that is actually the defining factor more than anything else. It means that when I wake up in the morning, instead of eating cornflakes, I eat bacon because my partner has told me to, even if I don't like it.
Thanks very much for your clarity on that. I want to turn to Professor Gill and her work with police, because it was actually local police forces who brought my attention to this spike in domestic violence during COVID. And quite often people say, well, police don't recognize this as a problem. But I also heard from police that they don't feel like they have tools once they do recognize that this is a problem. So Professor Gill, would you comment on your work with police on this question?
Thank you, Mr. Garrison. Absolutely. Police officers are aware of what's going on when they respond to different situations. But they have tools that they are working with, and they are called risk assessment tools. So in Canada, one of those risk assessment tools is called ODERA. And in many places, they are going to use this particular risk assessment tool. This assessment tool is used when there is physical violence or a threat of physical violence. So they perform an assessment when they see that, when there is evidence of physical violence. If there are other evidence of other things, it's not necessarily going to be assessed. I did a survey in New Brunswick with police forces, and we were asking about their perceptions about intimate partner violence. And so I have two camps. Those that are more traditional in their way of viewing IPV, and those that are more progressive, those that are more conservative and more traditional, are going to use the terminology from the Criminal Code of Canada. So talk about assault, sexual assault, while those that are more progressive are going to talk about coercion, jealousy, oppression in the relationship, or even isolation. So police officers know that something is happening. but they do not necessarily have the leverage to really do something about the situation besides sending a victim to a shelter, or maybe to issue an 810. So there will be a distance between the two partners, but there's not much that they are going to be able to do in terms of intervening. They can separate the parties, they can arrest the party, but there will be no charges that are going to be laid toward this particular person. You need to find some evidence. In order to find those evidence about coercive control, we need to give them the tools to be able to identify what is coercive control. That's what I would say.
Thank you very much, Professor Gill. Very quickly, in the little time remaining, I'd like to ask Ms. Illingworth. It turns out last year, your office and my office were working on this issue independently, and I only found out when you wrote to the minister. Can you tell us briefly why you wrote to the minister on this issue at the time you did?
Yes, very, very briefly. This is a concern of mine that comes from my background in frontline services, working with survivors. It's an issue that I continue to hear in my role as ombudsman. Survivors don't feel that there's an adequate criminal law response when they come forward to police. They feel that they cannot get assistance, that the person cannot be charged for the serious psychological, emotional, financial violence that they're suffering, and that the system doesn't view this as violence, this coercive and controlling behavior. So I see it as a real gap that still needs to be addressed in Canada.
Thank you. Thank you very much, Mr. Garrison. That concludes your time. And just really quickly, 2 members. I see that there are 3 minutes left before 1 p.m. Do I have consensus from members to go into the second round of questions, which will take us about 25 minutes to get through?
Oh my God.
I leave it to members, and I understand this is a very important topic, but obviously, so Mr. Garrison would like to go ahead, Mr. Cooper would like to go ahead, Mr. Virani, Mr. Moore, Monsieur Fortin.
Ben, moi, j'ai déjà des...
I already have things to do before the question period at 2, but perhaps we could extend for about 15 minutes without taking half an hour. Perhaps we could reduce the time that we extend. Just a suggestion.
Important.
It really is very important, but we have too many witnesses and too little time. Whether we're for or against, it's a very it's fascinating and important.
Mr. Lewis?
Thank you, Madam Chair. I am speaking in the House at 1:30 today. So if we go to 1:25, it's going to be very tough for me to log off this and then log back on to the other one. So I just wanted you to be aware. I didn't know I had to bring somebody to cover for me. So thanks.
You're absolutely fine. So would then members be okay if we just went through 1 member per party, which would bring us to about 15 minutes? Is that okay? Yeah. Okay. So we'll go ahead to Mr. Cooper for 5 minutes. Go ahead, sir.
Thank you, Madam Chair, and thank you to the witnesses. It's certainly helpful to look at what other jurisdictions have done as we consider Bill C-247, as well as the issue of coercive control more broadly. Ms. Illingworth, you noted that there were several U.S. states that had passed laws in this area. I actually wasn't aware of that. I understood that there is a bill in the New York General Assembly, as well as in the state of Tennessee. It's my understanding that its law on false imprisonment has been amended to include categories of behaviors that constitute domestic false imprisonment. Can you point to the other states so that we could give those laws consideration as we study this very important issue?
Yes, happy to. So Hawaii was the first state to enact anti-coercive control legislation, and my understanding is that New York and Connecticut legislatures have introduced similar laws. I don't know if they have passed there, but that is the information that I have from my awesome policy team.
Okay, thank you for that. I will direct my question to you, Ms. Illingworth, as well as Dr. Gill. Perhaps both of you could address this issue. It's certainly one important step to pass a law, but it's another to make it operational in terms of making it an effective tool for law enforcement. And when we look at other jurisdictions, we have not seen significant uptick in the way of prosecutions and convictions. For example, in the United Kingdom, at the end of 2018, there were only just over 9,000 offenses of coercive control in the context of 2 million incidents of domestic abuse in that year and only 308 convictions. And I guess there are some practical issues at play in terms of how law enforcement can lay a charge and how the Crown could successfully prosecute these cases. So can you just speak to some of those challenges and how, if this were passed or a similar bill were passed, how this tool could be an effective one to deal with this serious issue?
Would you like Carmen to go first?
Whoever wishes to answer first.
Okay, I will respond because we have to be quick. Well, if you go through the England and Wales situation, you are going to find that the Crown prosecutors have developed a handbook on how they are using the coercive control offense, and as well, police officers do have a risk assessment tool that they call the DASH that they are using. Of course, developing an offense like this will mean that there will need some resources to train those people to be able to implement this particular offense. Same thing with judges. They will need to understand what is the offense of coercive control if it moves forward.
Yes, and I would just echo that. I know the last witness has emphasized this as well, but implementation of the law is a completely a separate challenge. There needs to be judicial education, training of police and crowns, and then policies to accompany that ongoing training. So we can't just pass criminal law and hope that the situation is going to change. There have to be resources behind implementation, monitoring, evaluation, ongoing training.
Well, thank you. It just seems to me that there are significant challenges and difficulties in operationalizing emotional abuse in a legal context. And even though you speak to some of the things that have happened in the UK, the fact remains we've seen very few convictions. I think Dr. Gill, in your paper, you noted only 308 convictions. Was that since 2015?
That concludes your time, Mr.
Well, could I just maybe get a yes or no to that question?
I believe it was for 1 year,
okay.
2018.
Okay. Thanks for that clarity.
Thanks very much. We'll now go to Ms. Demoff for 5 minutes. Go ahead.
Thank you, Chair. Sorry, I had to unmute myself. Thanks to all the witnesses. I don't know, Ms. Gill or Ms. Silverstone, if you've done any research on this, but I've spoken to women in prison who have arrived in prison for, all three of them were drug trafficking because of coercive control. So Emily O'Brien, locally here, who's now out, had traveled with her partner. He seized her passport, had been threatening her throughout their relationship, but forced her to bring back drugs in return for getting her passport and being able to see her family again. So she served time because of mandatory minimums. I met women at the Edmonton Institute for Women who were in exactly the same boat. So I'm just wondering how often you see women who end up in prison themselves because of coercive control from their partner. Ms. Gill, perhaps you can start. I see you shaking your head. You're on mute.
Yeah. I've seen this in Saskatchewan when I was working at the University of Regina. I did a study with victims of intimate partner violence, and I've seen cases where the woman has been forced to prostitute herself, was locked in the house, and there was all sorts of behavior that she was subjected to, and she ended up being incarcerated because of what she was doing. But in the reality, she was victimized, but we have not necessarily seen this. And there are other examples I could give, but I will let Andrea talk.
I think you've hit the nail on the head. I actually, part of, I think, what twigged my understanding of coercive control and why it was so important is I actually started my career working in a halfway house for women coming out of federal corrections. And although they were there because of federal corrections reasons, I would say that the majority of clients who were in the halfway house had ended up in conflict with the law because of abusive partners who would coercively control them into drug trafficking, prostitution, a whole, theft, a whole variety of activities. And so I think that's why I think it's really important that we understand that coercive control is so much more than just domestic violence. It also can pertain to what I'll call modern slavery, essentially, right? Prostitution, non-consensual based drug trafficking, sex trafficking, all of those things.
So, I think my colleague, Mr. Maloney, wanted some time as well, so I'll pass it off to him.
Oh, thanks very much, Ms. Damoff. Look, just quickly then, I don't think anybody disagrees with the fact that a law of this nature is vital and necessary, but it's the application that I'm struggling with. And Mr. Moore, Mr. Cooper, and Mr. Fortin and others have touched on this. Ms. Gill, you described it as an abstraction. Ms. Illingworth, you said the application is more challenging. I agree with that. I mean, what you're doing is you're criminalizing behavior that individually may not be criminal, but collectively it is. That puts a great burden on a police officer who's called into a situation and is asked to investigate a complaint by a spouse for behavior that it's on its own may seem sort of innocuous. And I think this is what Mr. Fortin was getting at earlier. I mean, and if you look at that, Ms. Gill, in your paper, you set out what the Home Office statutory guidance framework is. I mean, you can easily pick 3 or 4 things off of that list that on their own don't seem troubling, but collectively they are. So, and maybe my question is for Ms. Silverstone, because I know you're in the business of training and working with groups. Do you feel confident that you could sit down with a group of judges or a group of police officers or any other group and train them in the way that they can apply this law so that you don't have difficulties at the expense of victims?
So my answer is absolutely yes. I think it has to be done with care and caution. I'm very lucky in that 2 years ago, I got to spend a month and a half in the United Kingdom meeting with the College of Policing and the Crown Prosecution Services to talk about exactly this issue as they were trying to do training as well as enculturate people to use the law. And one of the things that has happened because their training has gotten better and better, and because they have some statutory reviews of how they're doing it, is that the incidence of police officers using it, as they become better trained, they become more comfortable with using it, which then means they bring better evidence into court, which means the Crown is better able to do their job, et cetera, et cetera. And so if you look year over year, the coercive control legislation has been used by police and Crown prosecutors. It's going up 30% every year. So although the number is very small and it's only about 3% in 2019, I think that we're headed in the right direction, and we're very lucky in that other jurisdictions have done this work and they're already doing it. So we have a model that we can look at. But I know that police want to use a tool like this, and we would be giving them something that they want, not something they'd be resistant to.
Thank you very much. We'll now go to that concludes your time, Mr. Maloney. We'll go to Monsieur Fortin. 2.5 minutes, sir. Go ahead.
Merci, Madame la Présidente.
Thank you, Madam Chair. So briefly, I'm going to ask Ms. Gill just to tell me the list of jurisdictions where she suggests we should take a look. There was Scotland, there was England, Wales. What other jurisdictions should we look at? Hawaii was mentioned, Ms. Illingworth. Do you have any other suggestions? So for my part, I have 2 suggestions, those of England and Wales, and also those of Scotland, where they looked at either an offence of coercive control or It's okay. I only have 2 minutes. I'd like to talk about it all evening with you, but I'm afraid I have only 2 minutes. But I note that. Thank you for your answer. And the other question I have in my 2 minutes is regarding education. Ms. Silverstone said that she deals a lot with judge training of lawyers and police. So in terms of coercive control, how do we legislate or control to avoid that? My question is more of how we're going to educate. Right now, is there a program or something that exists to educate the population to work upstream and avoid having young boys or young girls too, because I know some young girls who are very controlling, to avoid having people develop that kind of behavior? Who could answer that question? I don't know. But education, not for the police, the judges and lawyers, but education for the population at large from a young age up.
That you have hit exactly where we need to be. We need to be getting upstream of this work, and we need to stop violence before it begins. And there is a lot of promising practices happening across Canada that are prevention programs. Alberta is actually working right now on a primary prevention framework, which is being led by my organization. It's a coalition of 500 organizations across Alberta working on that. But I plan to submit a written submission, and in that I could attach some research that has been done on that.
Merci, s'il vous plaît.
Yes, please, and thank you for that.
Yeah.
Can I add really quickly?
Oui.
Like a public health approach is really what we need in Canada. So education, training, criminal law responses, supports for survivors, and take a public health approach. Absolutely, we need to prevent upstream violence from happening, and we have obligations to the United Nations to prevent violence against women, the SDGs, and homicide in Canada as well.
Thank you very much. Thank you, Monsieur Fortin. We'll now go to Mr. Garrison, 2.5 minutes. Go ahead, sir.
Thank you very much, Madam Chair. And of course, I do think that these hearings before the Justice Committee are part of what Mr. Fortin is talking about, is our attempt to shine a light on this issue for the broader public. And for that, I thank the witnesses for being present today. I want to return to something that I think I'll use the word tends to sneak into our discussions, and that is a concern that there's some difficulty in recognizing the pattern of coercive and controlling behavior. And certainly in my discussions with frontline workers, I don't find any difficulty for them in recognizing what behaviors we're talking about. So can I ask each of the witnesses very quickly to comment on whether they believe it is difficult to recognize and define these patterns of behavior?
So I'll begin quickly, and I'll let you know that I think that it's very easy to define. And not only is it so easy to define, we've actually created a new tool that is being used with family law lawyers, mediators, and arbitrators that is literally 4 questions that clients can answer that will tell us whether or not there is coercive control in the relationship. It's very easy. We call it the fear factor. If one member of the relationship is afraid of the other person and adjusts their decision making as a result of it, that's coercive control.
It is going to be easy to define to recognize coercive control if they know what it is in the first place. So I will understand that people will not see it if they are not aware of what it is. And with an infraction, an offense, we would raise this particular awareness about coercive control.
Ms. Illingworth?
Yes, sorry, I was just having trouble with my mute button here. I would just reiterate that exactly some education is needed. People come into, no matter what field you're in the criminal justice system, you may come into your job with preconceived notions that psychological, emotional, financial abuse is not violence, but this is violence, and patterns of it. As I said, working on the front line, when you talk to survivors, they can describe what they are going through instantly, the fear, the isolation, the control that they're being dominated with. So it's just a matter of getting the tools that Andrea has described into the hands of those who are responding, on the first responders.
Thank you very much. Thank you, Mr. Garrison. And at this time, I'd like to thank the witnesses for your very compelling testimony. If there are any references to written submissions or other documents, please do make sure that you provide the committee with them. If there are any questions that were left half answered or unanswered, please, you are welcome to provide written submissions to the committee. Before members log off, I have 2 quick deadlines to remind members of. For your own benefits and to encourage people. One is with respect to written submissions for this study from stakeholders. The deadline would be February 28th by 12 noon. So please note that and do encourage stakeholders to write to us if they're not able to come in person. The second deadline I'd like to remind members of specifically, Tuesday, February 16th, end of day. If members can submit your witnesses for our next study, which is impacts of COVID on the justice system. And I'll remind members based on discussions that we had 8 witnesses for Liberals, 8 for Conservatives, 3 to Bloc Québécois, and 3 to NDP. And the deadline for that is end of day, Tuesday, February 16th. If there are any questions, please do get a hold of me after the meeting. Thank you again for a very, very worthwhile meeting, everyone. At this time, the meeting is adjourned.